believe we're live now.
The Honorable Court of Appeals for the 7th District of Texas is now in session.
We welcome you to the second argument of our January 6, 2021 settings of the 7th Court of Appeals via Zoom. And again, this is the second case that we have this morning, and I guess the last case that we have this morning. We appreciate counsel agreeing to attend by Zoom as if they had much choice. Given the circumstances now, if you want to argue, this is how we do it. Hopefully in the near future, things will change and you will be able to attend personally. I think it's a little bit more intimate that way. It's a better feel, but we live with the circumstances presented. With that said, have both the counsel argued before in the Supreme Court?
Yes, Your Honor.
Okay. So we'll dispense with various statements I say before, and we'll just go on and call the docket, and I'll get your announcements, even though we're pretty sure what they are, and go from there. The case that we are about to hear is 07-20-00082-CV. IEA Renewable Energy, Inc. versus Permian Basin Materials, LLC, DBA PB Materials Holding, Inc. Would say the appellants.
Lisa Norman for IEA Renewable Energy, Inc.
Thank you. And that believe?
This is Rhett Hubbard here on behalf of PB Materials.
Very good. And I will tell you now, throughout your briefs, you refer to PB Materials as PB, and I'm stuck in my mind as peanut butter. If I slip and say peanut butter, please excuse me.
That'll work.
Okay. With that said, Ms. Norman, you have the floor.
Thank you very much. And I'd like to reserve 5 minutes for rebuttal, please. May it please the court. This case arises from a construction contract in which the appellee PB Materials was hired to design and pour concrete for the base and pedestal of what was the largest windmill in North America at the time, which my client, the appellant IEA, installed in Lubbock, Texas. Today, I'm going to address 3 points. First, at a minimum, the judgment should be reversed because the evidence is legally and factually insufficient to support PB's recovery on its breach of contract claim. Second, because PB breached the contract first, the trial court erred by failing to grant IEA's motion for J&OV on the prior material breach defense. And third, the judgment should be reversed because the evidence is legally and factually insufficient to support that PB did not breach the agreement with respect to the Asr testing requirements. To begin with, the parties had competing breach of contract claims. The jury found that both parties breached. They found that there were 3 breaches on the part of PB. IEA had claimed that PB breached because it failed to design and provide the concrete mix per the specifications and per the project schedule. PB claimed that IEA breached because they didn't pay on time. And the dates that are important here for looking at who breached first, January 4th was when PB would have had to provide and pour the mix for the pedestal, which they admitted at trial they did not. And
do you view that there is a dispute with regard to breaches, that both parties breached, or is somebody saying, no, we did not breach at all?
No, I believe that both parties have admitted that there was a breach, but that the breach by IEA in terms of the failure to pay that first invoice that was due February 25th was excused by 1, the prior material breach of PB, which they admitted at trial, and 2, its obligation, IEA's obligation to pay was excused due to the offset provision in the contract that allowed them to offset the cost.
Is the issue then who breached first?
I believe that is the crux of the issue here, and that's what I believe the jury got wrong. And The evidence that's in the record is legally and factually sufficient, particularly with the admissions by PB, to show that PB breached this contract first. They were to provide that concrete mix per the specifications, and particularly the specifications that were provided in the engineering documents that were incorporated. Though, per the record, those specifications were provided to IEA on November 14th of 2017. The very next day, they were sent by IEA to PB, and PB admitted at trial that they never even opened or read the specifications.
One set of specifications?
I apologize, I couldn't hear you.
Was there only one set of specifications as to the concrete, the PSI, the strength, etc.?
Yes, there was only one set that applied. Those were the bar engineering specifications that were provided on November 14th to IEA and November 15th to PB. When
I read somewhere, and correct me, I'm a little confused then, I thought I read in opposing counsel's brief that there were, of course, there were specifications with regard to 6,500 PSI, but there were also specifications with regard to 5,000 PSI initially and some lesser PSI.
Yeah, so there were two different elements and two different specifications. There was a base and a pedestal. Those each had different requirements. On October 4th of 2017, when IEA first called for a quote, they only had some preliminary numbers that they were running, which were lower than what they ultimately ended up being. On November 1st, IEA then sent the updated numbers to PB, and ultimately the specifications that were provided by the engineer, which is what everyone was waiting on, they were called the issued for procurement plans. And they had the testing requirements, which had both a strength test and an ASR test.
What was the, when they made the initial phone call and said, hey, you want to do this for us, or made the inquiry, what were the proposed or potential specifications at that time? Then what were they in the first part of November?
Initially, it was 4,000 PSI for the base and 5,000 for the pedestal. And ultimately, the pedestal ended up being increased to 6,200 on November 14th. And that was all prior to the purchase order actually being signed by PB.
Did you say there was another discussion as to specifications the 1st of November?
The 1st of November is where the 4,000 and the 5,000 were first discussed. Those were when the strength numbers were first being discussed.
Okay.
And ultimately, the mix for the base is not in dispute. The mix for the pedestal is what we're talking about here. And the strength ended up not being the issue. It was the ASR test that they failed, which had to do with the expansiveness of the concrete. That ASR testing requirement was included in the document sent to PB on November 14th of 2017, prior to them signing the purchase order, in which they agreed to strictly comply with those requirements and perform all the specified tests at their expense. That purchase order that they signed in December incorporated the project schedule and those engineering drawings. And the problem, it appears, at the project ultimately resulted in the fact that, as PB admitted at trial, they never opened the document in the email that had the ASR testing requirements in it. They admitted they received it. They actually acknowledged that they had received the email by replying the next day, but they hadn't read the attachment, despite the fact that they then subsequently signed the purchase order agreeing to comply with the project schedule and the engineer's drawings. And so those engineer drawings are what had the ASR testing requirements in it. At the beginning of December, IEA emailed PB to ask what the test results were showing, and learned that PB hadn't even started the test yet at that time. The ASR test is one that takes 14 to 16 days. At this point in time, the parties were working with a December 3rd pour date. Ultimately, they agreed to move it to January 4th, but PB still failed to meet the January 4th date as well. They eventually disclaimed any liability and threw up their hands with respect to creating a mix that met the ASR test for the pedestal. And in fact, IEA had to work with the testing lab to come up with its own design.
What date was that Pavetex became involved?
That happened at the beginning of January 3rd.
So that was actually then before the date of the pour.
That was when they learned that there was not going to be a mix ready to pour the very next day. And they then reached out to Pavetex to see what they could do, because PB said that they were no longer going to be responsible for it.
My question was, the December 3rd pour date, is that in the specifications or in the purchase order someplace?
The initial pour date that was in was a December 22nd pour date that was in the purchase order. The parties then agreed to move it to January 4th. It actually ended up only moving the schedule by one day to move it to January 4th because the project was going to be shut down for the holidays anyway.
And
so
was that a written modification or an oral modification?
That was a written modification in the emails. And but the problem was that PB then didn't meet that January 4th date, and ultimately the pour didn't happen until January 3rd. The reason that's important is because General Electric was delivering the large windmill to be installed on the 15th of January. And so because the concrete hadn't been poured on the 4th as required, IEA ended up incurring costs for that delay in the form of the equipment that was rented and the laborers that were brought to the site for that purpose.
As to PB's argument, PB points out that the purchase order refers to there being an expected date of December 15th. Is there any language like that before the pour date, expected pour date of being the 3rd of December or 22nd, or expected pour date as being the 4th of January?
Sure, the January 22nd pour date is in the project schedule that was provided on November 14th by the engineer and incorporated into the purchase order, which was subsequently signed by PB. And the purchase order expressly stated that PB would comply with that project schedule. So the project schedule is what had the December 22nd pour date. It is again another document that PB admits it never looked at. Now, with respect to the respective breaches, as I stated, the first date by which IEA would have had to pay any of the invoices was the 25th of February, because the parties' agreement had a 45-day clock on any invoices that were issued, the first one being issued on January 11th. And so the first conceivable date by which IEA even could have breached for non-payment would have been February 25th. Since PB admitted that they didn't pour by the January 4th deadline, and as the jury found, they not only failed to adhere to the project schedule, but had breached the contract in 3 of the 4 respects for which we had alleged. All of those breaches occurred in the months of December and January. That PB's work on the job ended on January 30th. So all of their breaches would have occurred at a minimum 25 days before we even had a duty to pay. And so in terms of who breached first, and looking at it from a sufficiency of the evidence standpoint, there's no conceivable way that IEA could have breached for non-payment prior to any of PB's obligations, for which not only they admitted their failure to comply, but the jury found their failure to comply.
Why do you think the jury found the way it did?
I think obviously that's one of the issues always we're wondering after a jury verdict when it doesn't go the way that we think. And I think that they may have gotten confused, quite frankly, on the dates. Obviously, it's trial counsel's intent to try to get those dates straight in their head. But when they do get it wrong, that's why this appellate process exists. And here, the dates, when you look at the dates as shown in the record and as admitted to by PB, there's no conceivable way IEA could have breached prior to February 25th. And there's no duty that PB had after January 30th. And so there's no way that IEA could have breached first.
I may be misunderstanding opposing counsel's brief, but I thought I read something in there saying that something along the line that they could have complied with the dates, but for the engineer's demand that testing continue. And those demands, in effect, pushed them beyond the pour date.
Now, the engineering requirements were provided to them and agreed to by them in November. November 15th of 2017 is when those were provided. The requirements in terms of testing never changed from November 15th till the end in terms of that ASR testing requirement. That remained the same. It always had to be complied with on PB's part. It always had to be complied with before we could ever install the vertical portion of the windmill. And so nothing changed in terms of that ASR requirement after November 15th.
To the extent that the damages were awarded PB, what did they cover? The cost of preparation, or did they somehow cover the cost of the profit of what they would have gotten in a pour?
Based on the evidence alleged, it was both for the their labor in terms of designing the mixes, and then for pouring and providing the mixes themselves. However, PB admitted, and it's in the record at volume 5, page 204 and 206, that they did not provide the mix that ultimately got poured for the pedestal, despite the fact that they invoiced for that.
They didn't provide the mix, but did they provide basically the formula for the mix?
No, the ultimate formula that was used for the pedestal mix was the formula that IEA and the testing lab, PaveTex, ended up coming up with after PB said that they were disclaiming any further responsibility for providing that mix.
Well, when opposing counsel alludes to, or in their brief, alludes to the formula being 99% PBs, what is he alluding to?
That's what his client attempted to testify to at trial, but he also admitted when we showed him the formula for the mix that was ultimately poured, and that was in the record citation I just provided. We showed him the mix that was ultimately poured. He admitted that's what was poured and admitted that that was not PB's mix. And it was ultimately that formula that had to be revised and worked on by the testing lab and IEA in order to meet the ASR testing requirements. PB never could meet that with regard to the pedestal mix specifically.
Let me ask you a question about the relief you're seeking in the event that we reverse the judgment of the district court. The jury, did the jury ever reach the question of damages awarded to your client?
They did not, because it was predicated on a finding of who breached first. And so because they answered that IEA had breached first, they never got to the damages question. However, the damages that were presented at trial were not, there was no contradictory testimony presented whatsoever with regard to the number
Does that make them liquidated damages, or is that still something that has to be remanded to a fact finder for determination of what the damages are?
We believe
based
that
upon the evidence.
We believe that that based upon the evidence that was presented, that the fact finder would be able to issue judgment based upon the evidence that's in the record itself. That there would not be a need for a new trial for new evidence.
Was failure to mitigate some of the evidence that was presented at trial by the other side, by PB?
That was not one of the defenses to which evidence was presented, no. And in fact, what was shown at trial with regard to IEA's attempts to get the mix correct is that they were the ones that were pushing PB, requesting test results and trying to move it as fast as they could to get the mixes so that the pour could be done by January 3rd. And when PB said that they weren't going to be able to meet that on the 3rd, the very next day, IEA was in the lab with PaveTex.
What about on the attorney fee argument? Is that something that it looks like you're asking the court to render judgment on attorney's fees, but that seems pretty discretionary within the fact finder's discretion and assessment of the evidence.
So the attorney's fees that were presented for IEA was the $199,628. We do think that the record is not disputed at all with regard to the attorney's fees the attorney fee evidence that IEA presented, and therefore you would be able to render on the evidence that's in the record. At the very least, the trial court would be able to enter based upon the record and not need to take new evidence with regard to attorney's fees or the damages, which were not disputed either.
Attorney's fees, for instance, have got to be reasonable and necessary.
That is correct. And so the evidence that was—
You have witnesses saying that this is $100 is reasonable and necessary attorney's fees, and nobody disputes that. Is the fact finder obligated to adopt that, or can they say, no, we don't think that's reasonable nonetheless?
The fact finder still obviously has the ability to determine what's reasonable and necessary based on what's presented, even if it's not disputed.
So it's not necessarily something that can be, as a matter of law, we're entitled to these attorney's fees, this amount of attorney's fees.
No, it could be sent. It could be sent to the trial court for them to make a determination on the record, but no additional evidence would be necessary for them to be able to make a determination as to attorney's fees. All of the evidence is there in the record for that to be done.
And the measure of damages you were seeking, what were they composed of?
Those damages were composed of labor, material, and equipment costs that were incurred by IEA due to the delay by PB. And the contract specifically stated that the subcontractor PB would be liable for any and all costs and damages that IEA incurred due to PB's delay. And so
in awarding the damages under that formula, is there a reasonableness factor to consider? Or is it just whatever costs we incurred, you pay irrespective of the reasonableness?
The contract itself says that it would be all costs and damages that were incurred by the company due to the subcontractor's delay. And so the determination would be whether or not they are incurred because of delay. But in terms of the costs themselves here, the contract says that all those would be awarded to IEA, but the evidence at trial that was presented was that they were reasonable and necessary costs.
Thank you. Any other questions? Thank you, counsel. Mr. Hubbard?
Morning, Your Honor. May it please the court. You know, obviously we disagree with the facts recited by opposing counsel, and that tells you how heavily fact intensive this case was and how important the jury's understanding of the facts and credibility and who they're going to believe and who they're going to not believe played into this case. You know, this was a jury.
Yeah, Counsel, tell me, what do you perceive to be the first breach of IEA, and when did it occur?
I believe that it could have occurred as early as October 3rd, when Carson Dukes sent 4,000, 5,000 PSI pricing. We know that Bar Engineering published his specs on November the 1st, saying 6,200. She didn't tell us that till November 14th.
When was this contract agreed to?
Well, it was signed sometime in December. PB did a lot of work on a handshake for these guys and proceeded forward.
So it's your position that there was a breach of the contract before the contract was entered into?
Well, there sure was a lot of activity that took place by both sides prior to the purchase order being finally signed. The reason it took so long to get that purchase order signed was they kept sending inaccurate PSIs on the purchase order and had to keep changing it.
So was there an underlying agreement, in your view, between IEA and PB Materials to perform this concrete pour even before the purchase order was signed?
Absolutely, I think so. We were proceeding forward. Everybody agreed to the testing protocol. They knew the concrete had to be tested to meet Bar Engineering specifications. Everybody knew what the deal was, and we were proceeding with that testing on the assumption that they wanted to work with us. They could have said, when 6,200 came up and we said we got to start that from scratch, they could have said, well, fellas, we're going to go find somebody else who can do this now, but they didn't. They worked with us, and we substantially completed this deal. We finished the job. So there was a lot of activity in November and December. But I guess my answer to Judge Doss's question would be, at the instant the purchase order was signed and finally entered into, IEA was in breach of it.
Well, and what we know though is that whatever negotiations you had up until the time of the document, that those were necessarily merged into the document itself, or it went away, right? I mean, that's kind of the law in Texas merger doctrine for years, right?
I would think so. And there was no date certain ever agreed to by anybody. I mean, there's so many dates floating around. The purchase order says December 15th is the expected date. And then you got a construction schedule that says December 22nd is going to be the pour date. And then they said, well, January 3rd or January 4th is going to be the pour date. And it's telling that in opening statements, opposing counsel said, well, 12/22 is our hard date. And then in closing argument, they said, well, it's January 4th. And so the point is, there was no date certain other than what the purchase order said, which is that we will give you your concrete when promised. And when we promised to do that is when we passed all of ours testing and got a PE stamp, we'd be good to go. And
I may have led you astray a while ago or taken you off track from the chief's initial question to you, which was, what was the initial breach of the contract?
Well, I think there were multiple breaches. Them waiting 42 days to give us the correct specs, that was a problem. Them not being in compliance with the prime contract with regard to reporting and telling GE what's going on and keeping the construction schedule moving, that's a problem. Not moving the construction schedule is construction 101, according to Mr. Crouch. And
those may all be problems, but were they required by the contract that your client signed?
I believe that they were, because of the way that agreement was defined in the charge and the way that the purchase order was written. The prime contract was incorporated into the purchase order, and the charge itself defined agreement to include the prime contract. Absolutely. They had an obligation to do that just in the course of treating people right and doing business the way it's supposed to be done. That's one of the points of materiality, is you got to do your business the right way.
With regard to, was the purchase order the only contract your client signed?
Yes, sir.
Okay. With regard to the prime contract, and I guess you said the purchase order expressly incorporated the prime contract?
Yes, Your Honor, in paragraph 1 of the terms and conditions.
Did the prime contract specify pour dates?
Well, there was a construction schedule attached as an addendum. There were multiple construction schedules that came into evidence. One of them said the pour date's 12/22, and another one said the pour date's 1/4. But everybody knew the deal. Everybody knew our concrete was in a testing protocol. And
were any of the dates mentioned in the construction schedule after 1/4, January 4th?
Well, I mean, I guess the terms and conditions required us to follow BAR's specifications. BAR demanded that this stuff be tested. That testing takes a period of time. And so, yeah, I think it would go after that.
Were there any written pour dates later than January 4th?
I don't think so, other than at least nothing that came into evidence, Your Honor.
Did the purchase order itself have a pour date?
It said expected date 12/15. That's what it said.
12/15.
Yes, Your Honor.
And it said expected, quote unquote, expected?
Expected date 12/15. It was like at the top in the data section. That
was in the purchase order itself, right?
Yes, Your Honor.
The top right-hand corner of the purchase order says expected date 12/15.
Yeah.
I understand opposing counsel a while ago, she said though that in the specifications portion, there was a separate date of December 22nd as being the pour date, and there's not the word expected around that.
That's right. They have a construction schedule with everything that they're going to do, all the tasks that we need to get from point A to point Z. And one of those was pour foundation. And at one point it was 12/22. And then another time the schedule said 1/4.
And that was right. That was the date that the parties then went back and modified the agreement in writing to say that they're moving the pour date to January the 4th.
I don't know where that testimony exists. I don't know that we were ever agreeing to do anything other than get our concrete through the testing protocol.
Is there, and this may be a better question for the other side, are you saying you don't believe there's anything in the record that shows a written modification to January the 4th?
No, you're not letting, well, they may have done it in their schedule. They may have bumped the date, but we weren't signing off on anything. We weren't apprised of that. Our stuff's in the protocol for 28 days. That 28 days would pass on Christmas Day. And the ASR testing, it's important to point out, you know, our mix passed. It took some time, but we got a passing test on ASR, and we got it before they did, before this mix that they claimed that they designed that was 99.6% our mix.
What was the date that the ASR was complete?
Our ASR passed on January 22nd. IEA ordered concrete for the 24th and then ordered concrete for the 30th because their mix design passed at that point. You know, there was 4 times we could have timely gotten this done. You know, if Carson Dukes would have given us the specs early when they were issued by Bar Engineering, her engineer, we could have poured by mid-December. We could have met the expected date, but she didn't give us that information. We also...
When were they given to her by her engineer?
I'm sorry?
When were they given to her by her engineer?
Bar published the drawing with 6,200 PSI. It's dated November the 1st.
And when did she send them to you?
We got them on November the 15th. So that's 2 weeks.
Were you aware of getting them on November 15th?
We got the whole packet and we knew it was 6,200 PSI, and we had a conversation with them that day saying, we don't have that in our stock. We're going to have to start from scratch. The next day, Thomas Tilton and Brett Casper-Bauer had a conference call, and Brett said, okay, we want to work with you. Let's get it in the testing protocol. And that's what we did.
And when did you sign the purchase order?
I believe it was, the evidence came in, it was signed sometime in mid-December, finally. It went back and forth a number of times.
Did you have an opportunity at that point to say, we don't think we can meet your testing protocol with the new numbers?
I don't guess that conversation was ever had. And Mr. Crouch testified that the reason it wasn't had was because everybody knew what the deal was. And everybody knew December 25th happens after December 22nd. And we can't get 28-day test results until 3 days after your pour date. Everybody knew that.
And I guess that's what my question was. If you knew at the time that the 22nd wasn't going to be the actual pour date, then why not agree to a later date at that point before you signed your agreement versus waiting until later on to push it back to the 4th?
You know, I can only say that Mr. Crouch testified that number was dead on arrival. Everybody knew it. He knew it. IEA knew it, and BAR knew it. So there probably should have been some conversations about dates and such, but there just weren't. Not from them to us, and not really from us to them, except everybody knew we've got to test this stuff and get a passing grade, and then we'll pour it the next day.
When did you first become aware of the prime contract?
On November the 15th.
Okay. And November 15th is when you knew the construction schedules under the prime contract?
I don't know, Mr. Tilton is the one who testified about that. And what he said was he passed it along to somebody else above him in the chain of command. And
okay, you said a second ago in response to one of Justice Doss' questions that everybody knew that the dates were dead on arrival, so to speak.
Yes, Your Honor.
Did anybody so testify? Did anybody from IEA or their representatives so testify, or is that just something that everybody assumed?
Well, Mr. Casper Bauer testified that he had a conversation with us on the 16th of November. He knew that his engineer required a 28-day strength test, and that would end on Christmas Day. So I guess he didn't come out and say it was dead on arrival, but you have to imply that it is.
And that's as far as a pour date of December 22nd?
Yes, Your Honor.
But nothing with regard to a pour date of January 4th?
There were never any conversations that came into evidence between IEA and PB about there being a move to January 4th. We didn't really know that, I believe is what Mr. Tilton and Mr. Crouch testified to. But even if it was January the 4th, lithium would have solved the problem on January 3rd, and we could have poured timely. It befuddles me that this was not done and that IEA just told us to proceed with the testing. We could have done that and poured by January the 4th, and they didn't let us do it because they were concerned about the cost, $16,000.
So your argument is that you were ready to pour before January 4th, but we had a solution to solve the problem and get it done by January 4th. Yes, Your Honor. Did IEA provide you some type of formula that you were supposed to use in order to determine a mix for the pour? In other words, why did you have to go to IEA to say, hey, can we use lithium? Because our mix was in the testing protocol, and there were conversations about getting this thing moving forward, and it was proposed as a solution to solve the problem. Well, why couldn't you just use lithium? Say, because BAR's specifications were specific, and what the conversation was we need to go tell BAR, see if we can put lithium in there that will solve our problem. And Casper Bauer, in the same conversation, said, no, we're not going to do that. I don't want to do that. I don't like the cost. So it never even got to BAR. We can't talk to BAR. IEA has to talk to BAR. So there was some specification out there that prohibits you from unilaterally adopting or selecting lithium as a solution.
I don't think that would be appropriate. I think we're supposed to follow BAR's specifications as far as the recipe. And so that would be adding another ingredient to the recipe.
So the recipe says you put flour, salt, 2 eggs, and a pinch of ginger.
Right.
But you figure out in what quantities.
BAR, the specifications lay out exactly how it wants it done and how he wants it tested. And the addition of lithium would be adding a different ingredient. But it would
that to the ASR or to the PSI?
It would solve the problem with the ASR issue. But our mix passed ASR. It was a passing grade. It just took some time to get the test results back. That was the problem. We didn't fail at any point. We didn't fail ASR. It's an either or type deal.
Given the specifications they provide you, like my example, you put flour, et cetera, was there any argument that we could not get to the testing level or PSI that you want under those specifications?
No, and in fact, we did get there.
Let that happen.
I'm sorry?
Okay, what were you going to say? I cut you off. I'm sorry.
We did get there. We met BAR's recipe with the mix. It just took until January 22nd to get a passing grade from the test. And we could have used our mix that was initially done and poured on the 23rd. But they wanted to use this other mix. That was their choice.
Did you change your mix along the way? Or was it the same mix throughout and then it just has to be tested?
When we got the either or grade around the end of December, the engineer said, okay, we got an either or problem with this test. So run the ASTM 1557. That's what he recommended we did. And that's what we did. And we got a passing grade once that test was done.
But it wasn't complete until January the 22nd.
That's when we got the grade back from the engineer or from the lab saying this passes ASR, it passes strength, it's good to go.
If he had said run the ASTM 1557 and you said no, what would the result be on performance on the contract?
I think the engineer rules the roost, and we have to do what he says. I mean, he's GE's engineer and he's IEA's engineer. I don't think we could do that. I don't think anybody would let us pour.
When did he say that?
When did he say what?
Do the AS whatever test?
Yes, it was January 3rd is when we began the ASTM. We received orders from IEA on the 29th of December.
How long would that test take?
It took, I believe, 14 days.
So they had an engineer telling you, or GE, whoever was telling you, go on and do this testing while it was technically impossible to abide by that January 4th 4-day?
Yes, Your Honor.
Is that the tenor of your argument?
Yes.
Something along the line, and this is devil's advocate, but something along the line of, we had all these 4 dates, but they knew we couldn't meet them, but they kept egging us on, keep working. And then all of a sudden they said, oh, sorry, you breached, we're doing something else.
Yes, that's exactly right.
I'm a little confused about that. You didn't file a cross appeal challenging the jury's findings of that you had breached the contract, and you could have raised an impossibility of performance argument there. It looks like the issue on appeal that the other side has raised is that there's conclusive evidence that they didn't breach first. And so I'm trying to understand how your argument ties into whether or not they breached first.
Well, we were excused from our breach. The jury excused us either under a issue of waiver or an issue of estoppel or the issue of acceptance. The jury twice in 2 places said IEA breached first. Number one, they explicitly answered it in question 3. Who failed to comply first? IEA. Secondly, if you look at the excuse question that IEA submitted, The jury was also asked at that point, you were excused by PB's prior material breach, and the jury said no. So in both those places, they said PB was not the one who breached this deal first. And it's because of the expansive definition of agreement and the broad form submission that the jury received. They were well within their rights, and there is an overwhelming amount of evidence to show, as agreement is defined, that IEA breached it first.
Counsel, your time has expired. Any other questions? Thank you. Ms. Norman, you have 5 minutes.
Thank you very much. To clarify a couple of things, first of all, the engineer did not give a recipe. That was up to PB. What the engineer gave were testing requirements. It was PB's job to come up with a recipe that met those testing requirements.
Could PB have just added lithium on their own?
Yes, the recipe was entirely within their purview. All they had to do was meet both ASR and PSI testing requirements. And instead, they threw up their hands when they failed the test the first time. And as another point of clarification, one of the questions that was asked was, when did IEA get the engineer's drawings with the 6200? And the evidence shows, and it's in the record at volume 7, November 14th is when the engineer sent them to IEA, and November 15th, the very next day, IEA sent them to PB with the testing requirements included, the schedule showing December 22nd included. IEA highlighted in its email and on the drawings those testing requirements when they sent them on November 15th, and PB admitted they just never opened them. And it wasn't until 2 weeks later, actually it was December 3rd, IEA emailed and said, how are the tests going? And PB said they hadn't even started them yet. And so
let's assume, arguing, that that's all true.
Yes.
I think one of my first questions was, anybody disputing that both sides breached? And your answer was no, nobody's disputing that. I don't hear PB saying that we didn't breach. Let's assume they breached. You had a hard day, let's assume, of December 22nd. And that came and went. They didn't have their materials. But at that point, they tell your client or the engineers, we don't have it. And they say, but we're in the process of doing it. We got to do this testing, but it's going to take us, it's going to require us to continue on. And they say, okay. They said, well, you got to do the testing. Go on and do testing. Nobody said, King's X, you breached, you're gone, you're out. They said, do the testing. Why wouldn't that be enough to support a jury's view that there was an excuse by IEA or a waiver by IEA of PB's breach, Peanut Butter's breach? Because
those facts are not true, and it didn't happen that way. What happened and what was admitted to by PB was that after they failed the test and the test results were revealed, and it was known on January 3rd that, at least with regard to the pedestal, that they couldn't meet it, PB threw up their hands and said they weren't going to do it. And at that point, that's when IEA started working with Pavetex, only out of necessity and only because PB said they weren't going to do it anymore. They were still doing it with regard to the mix for the base, but with regard to the pedestal, they threw up their hands and said they would no longer do it. The other point I want to address is with regard to that prime contract. A moment ago, counsel said that it was incorporated into the contract that PB and IEA had. It was not incorporated on a wholesale basis. There were only specific provisions, the schedule and the technical specifications from the prime, that were incorporated into the agreement.
One quick question, if I go back to something you said, they threw up their hands and said they're not going to do it. Why did they continue on to do it if they said they're not going to do it?
The argument that I just heard that they continued on to do it is the first time I have heard that argument. The evidence trial did not show that to be the case.
You're disputing that there's evidence in the record to indicate that they had a mix that satisfied everything by mid to late January?
Yes, they did not have a mix. The only mix for the pedestal that ever passed ASR tests was the mix that IEA came up with PaveTex. And when that mix formula was shown to PB during the trial, and that specific portion of the testimony is actually called out in our brief and cut and pasted into the actual brief itself, where he admitted that that mix was not the one that they had designed. It was ours.
Counsel, I'm sorry. Go ahead and finish your sentence. I'm sorry. I've got a question that's going to take you back to your original statement.
Sure. PB never provided a mix for the pedestal that passed ASR testing.
Okay, let me ask you now. My understanding, and from what opposing counsel was saying a moment ago, and your response, and we went off and answered a different question, was dealing with the prime contract. And you said that the prime contract was not incorporated by reference wholesale, the entire contract. There were only certain portions.
That's correct. The schedule
Okay.
has technical specifications.
I'm looking at the jury charge right now, the jury charge that talks about the agreements, and agreements is defined in the charge as the materials purchase order together with the materials purchase order terms and conditions, the prime contract, and the project drawings and specifications. So if it wasn't a wholesale incorporation for purposes of your contract, didn't that instruction make it a wholesale incorporation by not specifying the limitations of the prime contract that's not being included? That was what's submitted to the jury.
Right. I don't believe that it did, but even if it did, let's just say for argument's sake that it did incorporate it all. PB is not a third-party beneficiary of that contract. There are no terms of that contract that they can say. If, in fact, they were specifically asked during their argument a moment ago, what did IEA breach in that contract? There was no provision and certainly no evidence ever that we breached anything in the prime contract, period. The only breach ever alleged and the only breach that they presented any evidence on was non-payment, period.
And so my question, I guess, is related to that. I understand your third-party beneficiary argument. I understand that there may not have been privity between PB and Prime. But right. Does any of that matter, given that the question that was asked of the jury as to your breach was the agreements in general, which includes the prime contract, which means if you breached your agreement with Prime, that would support a finding of yes as to breach under question 2.
I don't believe that it does. But if I take it a step further, and even if we were to say, okay, the jury came up with something on their own, there's no evidence of any breach of the prime, but let's just say that they did. The damages that PB requested were because of damages that it would have incurred because of any failure to comply with the agreement by IEA. And the damages that they incurred are only the invoices that weren't paid. And that would not correlate to any alleged hypothetical breach that nobody ever talked about or there's any evidence of the prime. They can only recover for damages resulting that they incurred because of a failure to comply by IEA, and those are only non-payment of invoices.
I know that time's expired, and I know that the normal procedure is all the attorneys had their opportunity to make their presentation. I've got a question that is troubling me. And I'm going to direct it to Mr. Hubbard, and I'll give you, Ms. Norman, an opportunity to respond. But it relates to the existence of evidence that PB ultimately came up with a mix that passed. And they did that in January 23rd or something like that. Mr. Hubbard said they did. Ms. Norman says, no, there's no evidence of that. Mr. Hubbard, where's the evidence?
Your Honor, I believe that is in Mr. Crouch's deposition testimony, and I was looking at the graphic timeline that we attached as an appendix. It's just a handy reference for me. and Mr. Crouch created that. And he says PB receives positive ASR test result in forms IEA January 22, 2018. And then star 4 is use of PB initial mixes to solve the problem.
And that deposition testimony was admitted at trial.
I believe Mr. Crouch talked about that, yes. I can dig through my facts here and find the site.
We'll go through your brief again. Okay, thank you. Ms. Norman?
Yes, they met ASR tests with regard to the base, but never the pedestal. And the evidence in the record shows that Mr. Crouch admitted as such, and that's included in our brief as well. They never met ASR testing with regard to pedestal, period.
Well, the January whatever, 20 whatever date was as to the base only.
Yes, they had the mix ready with ASR tests for the base on that date, yes.
Okay. Thank you, Councilor. Any other questions? We thank you very much for appearing through Zoom. And we are, let me just say this, your case is submitted and you are excused to leave, and we will be in recess. Again, thank you very much, and hopefully in the near future we get to see you in person.